news. The Justice Department is now formally appealing that ruling that sided with Trump, authorizing a special master to do an additional or separate review of the materials seized. DOJ also wants to pause the judge's order that would purport to bar them from using those documents in what is this open probe. And with respect to 100 classified documents seized from Mar-a-Lago, the filing says it, quote, does not and could not assert that he owns or has any possessory interest in the classified records, or that he could advance any plausible claims of attorney-client privilege. In other words, a kind of a carve-out where they're saying no matter what happens, the stuff that they say he stole that isn't attorney-client privilege and belongs to the intelligence community is not something that needs to be specially reviewed at all. The DOJ wants to do this, and this comes 3 days after the ruling that was approving the special master by a judge in Florida. Donald Trump's lawyers went to that judge who was appointed by him when he was president, apparently seeking what they thought would be a better outcome. Meanwhile, a different Trump grand jury investigation is coming to light. The fundraising efforts after the election getting new scrutiny by the feds. The grand jury here has issued subpoenas, apparently, from New York Times reporting that suggests they want more information about Donald Trump's political action committee, which was raising millions of dollars in that critical period leading up to the insurrection. We're now joined by an expert on so many of these issues at once. Asha Rangappa was an FBI agent as well as a lawyer and a law professor. Welcome back.
Thanks for having me.
What do you think of this appeal?
I think the appeal is excellent. It's very clearly written, and it is asking for basically a limited relief from the judge's order. So what they're asking the judge to do is to issue a partial stay of her own order to essentially, as you said, Ari, carve out the classified documents and say these should not be a part of the special master review. And they offer three arguments for this. The first is they reject that there's any executive privilege over classified documents, not only because they're evidence of a crime, and U.S. v. Nixon makes this an exception to executive privilege, but also because the executive branch controls classified information and they shouldn't be prevented from accessing it themselves. The second argument, and this is the most compelling, I think, Ari, is that they say that the judge artificially bifurcated the criminal part of the investigation from the national security part. If you'll remember, she originally said, well, the intelligence community can continue its classification review, but the criminal division can't continue its investigation. And what they say is that these two things are intertwined. So, for example, the classification review is relevant to whether a crime actually happened. And in order for the IC to determine whether methods and sources have been compromised, the FBI actually has to continue its investigation to see whether these records were accessed. And this, I think, will carry great weight because the executive branch is the branch that has the expertise to know what it needs to do to fulfill its national security function. And the last argument basically is Trump just doesn't have any possessory interest in these classified documents. I mean, these aren't his medical records. These aren't his taxes. And so, you know, this is not harming him in any way to take these out of the mix.
Yeah, and in all fairness, the only issue there would be potential mistakes. Human error can happen where something might have been taken accidentally or might have been mixed up in there and then you have to give it back. That doesn't seem to be, there's no evidence that that happened a lot or is a big problem. There's much more evidence from something as simple as the photographs that we have seen to the more meticulous way that they document this stuff, that they went in, reviewed it, and took it. And so, you know, possessory interest is one of those words where it's like they're talking about stuff he stole. That's what they're saying. Now, he has every right to deny that, and that could be litigated. But the government's position, overseen by the magistrate in the original warrant, is you stole a bunch of stuff. Obviously, you don't have a big say in what's reviewed because it's not yours to begin with, which is why we had to come in and take it back. To what you defined as point two, the overlapping interests, I'll just read a little bit more from the appeal. They reference the, quote, uncertainty about the bounds of the court order and the implications for the FBI, which has caused the intelligence community to, quote, pause temporarily what they call critically important work, Asha.
Yes, and the reason this is so important is that Judge Cannon's justification for appointing this special master and making sure that, that the documents are properly filtered was because she thought that there could be potential injury to Trump, reputational harm, right? That, if it followed the normal course that it might in a criminal process, waiting until an indictment, filing a motion to suppress, that he's already suffered the stigma of being indicted. And I think when you read this DOJ filing, you realize how relatively trivial that harm is compared to our government having to halt a review of the national security implications and damage that may have been caused by Trump holding these documents. I mean, if she decides to not grant this partial stay, she will be putting the importance of the reputation of the former president above the national security interests of the United States. And I think that it would be astonishing. I'm not sure it would be surprising at this point. It would be astonishing. But at that point, DOJ can appeal to the 11th Circuit. And I think that they have a good case because generally the executive branch is given great deference when it comes to matters of national security.
Then you have this other investigation, as mentioned, with the funding of activities that we know was around the period after Trump had lost, going into what became the insurrection. What do you see in that newly revealed aspect of that probe?
Well, in that aspect, I see a couple of things. First, this is a separate thread that's being investigated apart from the incitement of, insurrection, the attack on the Capitol, the false elector scheme. This is really about the funding and essentially what appears to be a fraudulent scheme to raise money. This Save America PAC raised $250 million, claiming that they were going to be using it to fight election fraud. And clearly there wasn't anything to fight at that point. And so this investigation is pursuing a new thread. It's also being done with a separate grand jury and with a separate prosecutor. And I think this is really important because it means that the Department of Justice is really devoting resources to looking at all of these different threads. And I think that was a real concern before, given the breadth of this investigation. I think the largest investigation probably in DOJ's history, having to prosecute all of the on-the-ground people and then look into all of these other threads. Did they have the manpower? But it looks like they're finding the manpower to do multiple different angles simultaneously.
Understood. Asha, good to see you, as always, on a very busy news night.